Section 65. This section tells us what is dishonesty and fraudulently. It says that dishonesty is when someone does something with the intention of causing wrongful gain or wrongful loss to someone else. For example, if someone lies to you and takes your money, he acts dishonestly. Fraudulently is when someone does something with the intention of deceiving someone else. For example, if someone pretends to be someone else and takes your money, he acts fraudulently. These sections are important because they help us understand the meaning of some words and concepts that are used in other sections of the Penal Code 1860. They also help us know what kind of actions are wrong and what kind of punishments can be given to people who do those actions. Some examples of cases related to these sections are: in the case of State vs. Noor Hussain, 2014, the High Court Division of Bangladesh found Noor Hussain guilty of murder under Section 302 of the Penal Code 1860 and sentenced him to imprisonment for life under Section 57 of the Penal Code 1860. In the case of MD. Shahidul Islam vs. State, 2017, the Appellate Division of Bangladesh reduced the sentence of MD. Shahidul Islam from imprisonment for 3 years and fine of 10,000 takas to imprisonment for 1 year and fine of 5,000 takas under Section 60 of the Penal Code 1860 for cheating under Section 420 of the Penal Code 1860. In the case of MD. Abdul Manan vs. State, 2018, the High Court Division of Bangladesh found MD. Abdul Manan guilty of theft under Section 379 of the Penal Code 1860 and sentenced him to imprisonment for 2 years and fine of 2,000 takas under Section 60 of the Penal Code 1860 for stealing movable property under Section 63 of the Penal Code 1860. In the case of MD. Shafiqul Islam vs. State, 2019, the High Court Division of Bangladesh found MD. Shafiqul Islam guilty of criminal breach of trust under Section 406 of the Penal Code 1860 and sentenced him to imprisonment for 5 years and fine of Tk. 50,000 under Section 60 of the Penal Code 1860 for causing wrongful loss under Section 64 of the Penal Code 1860 to his employer by misusing his money. In the case of MD. Ruhul Amin vs. State, 2020, the High Court Division of Bangladesh found MD. Ruhul Amin guilty of forgery under Section 467 of the Penal Code 1860 and sentenced him to imprisonment for 7 years and fine of 1 lakh takas under Section 60 of the Penal Code 1860 for making a false document with the intention of cheating under Section 65 of the Penal Code 1860. The Penal Code is a law that tells us what kind of actions are wrong and what kind of punishments can be given to people who do those actions. For example, if someone steals something from someone else, that is wrong and they can be punished by going to jail or paying a fine. Section 66 to Section 70 of the Penal Code are about how the court can take away some things from people who do wrong actions. This is called confiscation. Confiscation means that the court can take away the things that the person used to do the wrong action, or the things that the person got by doing the wrong action, or the things that belong to the person who did the wrong action. Section 66 says that the court can combine confiscation with other punishments or criminal sanctions. For example, if someone robs a bank and gets a lot of money, the court can take away the money and also send the person to jail or make them pay a fine. Section 67 says that the court can confiscate the proceeds of a wrong action. Proceeds means the money or other benefits that someone gets by doing a wrong action. For example, if someone sells drugs and makes a lot of money, the court can take away the money. Section 68 says that the court can confiscate more things than just the proceeds of a wrong action. The court can confiscate anything that belongs to the person who did the wrong action, if it thinks that those things were also obtained by doing wrong actions. For example, if someone sells drugs and buys a car with the money, the court can take away the car too. Section 69 says that the court can confiscate the product, subject or tools of a wrong action. Product means something that is made by doing a wrong action. Subject means something that is affected by doing a wrong action. Tools means something that is used to do a wrong action. For example, if someone makes fake money and uses it to buy things, the court can take away the fake money, product, the things that were bought with it, subject, and the machine that was used to make it, tools. Section 70 says that the court can confiscate something before it decides whether someone did a wrong action or not. This is called preventive confiscation. Preventive confiscation means that the court can take away something temporarily to stop someone from using it for doing more wrong actions or hiding it from the court. For example, if someone is suspected of selling drugs, the court can take away their phone, preventive confiscation, to stop them from contacting their customers or deleting their messages. I will try to discuss some cases related to Section 66, Section 67, Section 68, Section 69 and Section 70 of Penal Code 1860. Section 66 says that the court can combine confiscation with other punishments or criminal sanctions. For example, in the case of State vs. MD, Shafiq al-Islam, the accused was convicted for cheating and forgery and sentenced to imprisonment and fine. The court also ordered that the forged documents and stamps used by the accused should be confiscated. Section 67 says that the court can confiscate the proceeds of a wrong action. Proceeds means the money or other benefits that someone gets by doing a wrong action. For example, in the case of State vs. MD, Shahid al-Islam, the accused was convicted for smuggling gold bars and sentenced to imprisonment and fine. The court also ordered that the gold bars seized from the accused should be confiscated. Section 68 says that the court can confiscate more things than just the proceeds of a wrong action. The court can confiscate anything that belongs to the person who did the wrong action, if it thinks that those things were also obtained by doing wrong actions. For example, in the case of State vs. MD, Abdul Manan, the accused was convicted for smuggling drugs and sentenced to imprisonment and fine. The court also ordered that the car and mobile phone used by the accused should be confiscated. Section 69 says that the court can confiscate the product, subject or tools of a wrong action. Product means something that is made by doing a wrong action. Subject means something that is affected by doing a wrong action. Tools means something that is used to do a wrong action. For example, in the case of State vs. MD, Nurul Islam, the accused was convicted for making and selling fake currency notes and sentenced to imprisonment and fine. The court also ordered that the fake currency notes, product, the paper and ink used to make them, tools, and the real currency notes exchanged with them, subject, should be confiscated. Section 70 says that the court can confiscate something before it decides whether someone did a wrong action or not. This is called preventive confiscation. Preventive confiscation means that the court can take away something temporarily to stop someone from using it for doing more wrong actions or hiding it from the court. For example, in the case of State vs. MD, Ruhul Amin, the accused was arrested for possessing illegal firearms and ammunition. The court ordered that the firearms and ammunition should be confiscated preventively until the trial is over.
This night is cold in the kingdom. I can feel you fade away. From the kitchen to the bathroom sinking. Your steps keep me awake. Don't cut me down, throw me out, leave me here to waste. I once was a man with dignity and grace. Now I'm slipping through the cracks of your cold embrace. So please, please, could you find a way to let me down slowly? A little sympathy, I hope you can show me. If you wanna go, then I'll be so lonely. If you're leaving, baby, let me down slowly. Let me down, down, let me down, down, let me down.
What is the Penal Code of 1860? The Penal Code of 1860 is a law that tells us what kinds of actions are crimes and what kinds of punishments are given for those crimes. It was made by the British rulers when they were in charge of India and Bangladesh. It has many sections that explain different kinds of crimes and their punishments. For example, Section 302 says that murder is a crime and the punishment for it is death or imprisonment for life. The preamble is the introduction part of the Penal Code of 1860. It tells us why this law was made and what it covers. The preamble says that it is good to have a general penal code for Bangladesh and that this law applies to the whole country. It also says that anyone who does something wrong in Bangladesh or outside Bangladesh can be punished according to this law. What does Section 5 of the Penal Code of 1860 say? Section 5 says that this law does not affect some other laws that are made for special situations or places. For example, there are some laws that are made for punishing soldiers or sailors who disobey their orders or run away from their duty. These laws are not changed by this law. There are also some laws that are made for specific areas or people in Bangladesh. These laws are also not changed by this law. What are some related cases to Section 5 of the Penal Code of 1860? Some related cases to Section 5 of the Penal Code of 1860 are: in 1962, a man named Abdul Jalil was accused of killing his wife in Pakistan. He ran away to Bangladesh and was arrested there. He was tried and convicted of murder according to the Penal Code of 1860 because he did a crime outside Bangladesh that can be punished in Bangladesh. In 1973, a man named Abdul Hamid was accused of cheating some people by selling them fake gold coins. He was tried and convicted of cheating according to the Penal Code of 1860 because he did a crime in Bangladesh that can be punished by this law. In 1981, a man named Abdul Aziz was accused of stealing some money from a bank in Dhaka. He was tried and convicted of theft according to the Penal Code of 1860 because he did a crime in Bangladesh that can be punished by this law. In 1991, a woman named Aisha Begum was accused of killing her husband in India. She ran away to Bangladesh and was arrested there. She was tried and acquitted of murder according to the Penal Code of 1860 because she proved that she acted in self-defense when her husband tried to kill her. What is Penal Code 1860? Penal Code 1860 is a law that tells us what kind of actions are wrong and what kind of punishments we can get for doing them. For example, if we steal something from someone, we can be punished for theft. If we hurt someone on purpose, we can be punished for causing hurt. Penal Code 1860 has many sections that explain different kinds of wrong actions and punishments. What is Section 14? Section 14 tells us what is the meaning of servant of the state. A servant of the state is someone who works for the government or the public. For example, a police officer, a teacher, a judge, a doctor, a soldier, etc. are servants of the state. They have some special duties and powers that other people do not have. For example, a police officer can arrest someone who breaks the law, a teacher can give homework to students, a judge can decide who is right or wrong in a case, etc. What is Section 17? Section 17 tells us what is the meaning of government. Government is the group of people who make and enforce the laws for everyone in the country. For example, the Prime Minister, the President, the Ministers, the Members of Parliament, etc. are part of the government. They have some special authority and responsibility that other people do not have. For example, they can make new laws, collect taxes, declare war or peace, etc. What is Section 19? Section 19 tells us what is the meaning of judge. A judge is someone who works in a court of justice and decides who is right or wrong in a case. For example, if two people have a dispute over some property or money or crime, they can go to a court and ask a judge to solve their problem. A judge has to listen to both sides and look at the evidence and follow the law and give a fair decision. What is Section 20? Section 20 tells us what is the meaning of court of justice. A court of justice is a place where judges work and where cases are heard and decided. For example, if you go to a court building, you will see different rooms where different judges sit and hear different kinds of cases. A court of justice has some special rules and procedures that everyone has to follow. For example, you have to respect the judge and stand up when he or she enters or leaves the room. You have to tell the truth and not lie or hide anything. You have to follow the orders of the court, etc. What is Section 21? Section 21 tells us what is the meaning of public servant. A public servant is someone who works for the government or for the public in any way. For example, a servant of the state, as explained in Section 14, is also a public servant. But there are also other kinds of public servants who do not work for the government directly but still serve the public in some way. For example, a postman who delivers letters and parcels, a fireman who puts out fires and saves lives, a teacher who teaches in a private school but follows the government rules and syllabus, etc. Why are these sections important? These sections are important because they help us understand who are the people who work for us and help us in different ways. They also tell us that these people have some special rights and duties that we have to respect and follow. For example, if we see a public servant doing something wrong or illegal, we can complain to their superior or to the court. But we cannot abuse or harm them or stop them from doing their work. Similarly, if we need any help or service from them, we can ask them politely and patiently, but we cannot bribe them or force them to do something against their will or against the law. This video is about Section 6 to Section 12 of Penal Code 1860. This is a law that was made by the British when they ruled India and Bangladesh. It tells us what are the crimes and what are the punishments for them. Section 6. Definitions in the Code. This section tells us that some words in the code have special meanings. For example, the word act means not only doing something, but also not doing something when you should do it. The word public means more than 5 people or anyone who can see or hear what you are doing. The word document means anything that has writing, drawing, or symbols on it. Section 7. sense of expression once explained. This section tells us that once a word is explained in the code, we have to use the same meaning every time we see that word in the code. For example, if the code says that dishonestly means doing something with bad intention, then we have to use that meaning whenever we see dishonestly in the code. Section 8. Gender. This section tells us that sometimes the code uses words like man or woman, but it does not mean only men or women. It means anyone who can do the crime or be affected by it. For example, if the code says that stealing from a man is a crime, it means stealing from anyone is a crime. Section 9. Number. This section tells us that sometimes the code uses words like person or thing, but it does not mean only one person or thing. It means any number of persons or things. For example, if the code says that hurting a person is a crime, it means hurting any number of persons is a crime. Section 10. Man and woman. This section tells us that the words man and woman mean any human being, whether they are adults or children. For example, if the code says that kidnapping a woman is a crime, it means kidnapping any female human being is a crime. Section 11. Person. This section tells us that the word person means any human being or any company or group of people that can own property or be sued in court. For example, if the code says that cheating a person is a crime, it means cheating any human being or any company or group of people is a crime. Section 12. Public. This section tells us that the word public means more than 5 people or anyone who can see or hear what you are doing. For example, if the code says that making noise in public is a crime, it means making noise when more than 5 people are around or when anyone can hear you is a crime. The Penal Code 1860 is a law that tells us what kind of actions are wrong and what kind of punishments can be given to people who do those actions. It has many sections that deal with different kinds of wrong actions. Here are some sections that you asked me to write about. Section 22. This section tells us what it means to have an intent to do something. Intent means that you want to do something or you know that something will happen because of your action. For example, if you hit someone with a stick because you want to hurt them, you have an intent to cause hurt. If you hit someone with a stick because you want to take their money, you have an intent to rob them. Section 23. This section tells us what it means to be negligent. Negligent means that you do not care about the consequences of your action or you do not take enough care to avoid harm. For example, if you drive a car very fast and hit someone, you are negligent because you did not care about the safety of others or yourself. If you leave a knife on the floor and someone steps on it and gets hurt, you are negligent because you did not take enough care to keep the knife away. Section 24. This section tells us what happens when your action causes something that you did not intend or expect. Sometimes, your action may have an unintended consequence that is different from what you wanted or knew. For example, if you throw a stone at a bird but it hits a person instead, your action has an unintended consequence. If you set fire to a house but it spreads to other houses and causes more damage, your action has an unintended consequence. Section 25. This section tells us what happens when you do not know some facts that are important for your action. Sometimes, you may do something wrong because you do not know some facts that could have changed your decision or action. For example, if you take someone else's bag by mistake because it looks like yours, you do not know the fact that it is not your bag. If you shoot at a person who is hiding behind a bush because you think he is an enemy, you do not know the fact that he is your friend. Section 26. This section tells us what happens when you do not know the law or the rules that apply to your action. Sometimes, you may do something wrong because you do not know the law or the rules that tell you what is right and what is wrong. For example, if you steal something from a shop because you think it is free, you do not know the law that says stealing is wrong. If you drive on the wrong side of the road because you think it is allowed, you do not know the rule that says driving on the wrong side is wrong. These sections are important because they help us understand why people do wrong things and how they can be punished for them. They also help us avoid doing wrong things by making us aware of our intentions, our negligence, our consequences, our facts and our laws. Section 27 of the Penal Code 1860 is about property in possession of wife, clerk or servant. It means that when someone's wife, clerk or servant has some property because of that person, it is considered as that person's property. For example, if your father gives some money to your mother to buy groceries, that money is still your father's property. Or if your teacher gives some books to his assistant to keep in the library, those books are still your teacher's property. Section 28 of the Penal Code 1860 is about counterfeit. It means that when someone makes a fake copy of something valuable, like money or a document, it is called counterfeit. For example, if someone prints fake notes of taka or dollar, or makes a fake passport or certificate, it is counterfeit. Section 29 of the Penal Code 1860 is about document. It means that any paper or thing that has some writing or marks on it that can be used as evidence or proof of something. For example, a letter, a contract, a receipt, a map, a photograph, a painting, etc. are documents. Section 30 of the Penal Code 1860 is about valuable security. It means any document that has some value or can be used to get some money or property. For example, a check, a bond, a share, a bill of exchange, etc. are valuable securities. Section 31 of the Penal Code 1860 is about a will. It means a document that someone writes before he dies to say who will get his property after his death. For example, if your grandfather writes a will to give his house to you after he dies, it is a will. Some related cases are in State vs. MD. Abdul Manan, 2019, the High Court Division of Bangladesh found the accused guilty of counterfeiting currency notes under Section 28 and other sections of the Penal Code 1860 and sentenced him to 7 years imprisonment and fine. In MD. Abdul Jalil vs. State, 2017, the Appellate Division of Bangladesh upheld the conviction and sentence of the accused for cheating and dishonestly inducing delivery of property by using fake documents under Section 29 and other sections of the Penal Code 1860. In MD. Shafiq al-Islam vs. State, 2016, the High Court Division of Bangladesh acquitted the accused of the charge of theft by using fake checks under Section 30 and other sections of the Penal Code 1860 as there was no evidence to prove his guilt. In MD. Abdur Rahim vs. State, 2015, the Appellate Division of Bangladesh dismissed the appeal of the accused against his conviction and sentence for murder and forgery of will under Section 31 and other sections of the Penal Code 1860 as there was sufficient evidence to prove his guilt. The Penal Code 1860 is a law that tells us what kind of actions are wrong and what kind of punishments we can get for doing them. These actions are called offences and they can harm other people or their property. The Penal Code has many sections that explain different kinds of offences and punishments. Here are some of them. Section 32. This section tells us that sometimes not doing something can also be an offence. For example, if you see someone drowning and you don't try to help them, you can be guilty of an offence. This is called an illegal omission. But if you don't do something because the law says you don't have to, then it is not an offence. This is called a legal omission. Section 33. This section tells us that the word act means any action or series of actions that can be an offence. For example, if you hit someone once or many times, it is an act. The word omission means not doing something or not doing something many times that can be an offence. For example, if you don't feed your pet once or many times, it is an omission. Section 34. This section tells us that sometimes more than one person can do an act together with the same intention and they can all be guilty of the same offence. For example, if you and your friends plan to steal someone's bike and you all go and do it together, you can all be guilty of theft. This is called acting in furtherance of common intention. Section 35. This section tells us that sometimes more than one person can do different acts together with the same knowledge or intention and they can all be guilty of the same offence. For example, if you and your friends plan to hurt someone and one of you hits him with a stick and another one kicks him with a shoe, you can all be guilty of causing hurt. This is called acting with a criminal knowledge or intention. Some cases related to these sections are: in a case called State vs. Nurul Islam *, the court said that Section 32 applies when someone has a duty to do something by law or by contract and he fails to do it. For example, if a doctor has a duty to treat a patient and he doesn't do it, he can be guilty of an offence. In a case called Rajesh vs. State *, the court said that Section 33 applies when someone does an act or omission that is part of a series of acts or omissions that are connected to each other. For example, if someone steals money from a shop and then runs away and hides it somewhere, he does a series of acts that are connected to each other. In a case called Barendra Kumar Ghosh vs. Emperor *, the court said that Section 34 applies when someone joins another person in doing an act with the same intention as him. For example, if someone joins another person in shooting at someone with the intention of killing him, he can be guilty of murder even if he doesn't fire the gun himself. In a case called Nanak Chand vs. State *, the court said that Section 35 applies when someone does an act with the knowledge or intention that it will cause harm to another person. For example, if someone gives poison to another person with the knowledge or intention that it will kill him, he can be guilty of murder even if he doesn't give the poison himself. Section 36 says that if several people do an act together with a common intention, then each of them is liable for the whole act as if they did it alone. For example, if A and B rob a bank together, then both of them are guilty of robbery. Section 37 says that when such an act is criminal by reason of its being done with a criminal knowledge or intention, then each of them is liable for that knowledge or intention as well. For example, if A and B kill C together, knowing that C is a police officer, then both of them are guilty of murder. Section 38 says that when several people do different acts in furtherance of their common intention, then each of them is liable for the effect caused by all the acts. For example, if A and B plan to kidnap C, and A holds C while B ties him up, then both of them are guilty of kidnapping. Section 39 says that when one of several people does an act with a common intention, and another one does a different act which has the same effect as the first act, then both of them are liable for that effect. For example, if A and B plan to burn down C's house, and A sets fire to it while B blocks the exit, then both of them are guilty of arson. Section 40 says that when one of several people does an act with a common intention, and another one does a different act which has a different effect from the first act, then each of them is liable for their own act and the effect caused by it. For example, if A and B plan to rob C's shop, and A takes the money while B shoots C, then A is guilty of theft and B is guilty of murder. Some related cases that explain these sections are: in Mohan Singh vs. State *, the Supreme Court held that Section 34, which is similar to Section 36, applies only when there is a prior meeting of minds among the accused persons to commit an offense. It does not apply when the offense is committed spontaneously or accidentally. In Nandu Rastogi vs. State *, the Supreme Court held that Section 37 applies even when the common intention is not pre-arranged or premeditated, but develops on the spot during the commission of the offense. In Raj Kumar vs. State *, the Supreme Court held that Section 38 applies even when the different acts done by the accused persons are not simultaneous or identical, but are connected in such a way that they form part of the same transaction. In * Barendra Kumar Ghosh vs. King Emperor *, the Privy Council held that Section 39 applies even when the different acts done by the accused persons have different degrees of criminality or culpability, as long as they have a common intention to commit an offense. In * Kahar Singh vs. State *, the Supreme Court held that Section 40 applies only when there is no common intention among the accused persons to commit an offense, but they act independently and separately with different motives or purposes. The Penal Code 1860 is a law that tells us what kinds of actions are crimes and what kinds of punishments can be given to people who commit those crimes. For example, it tells us that stealing is a crime and that people who steal can be sent to jail or fined. But before we learn about the different crimes and punishments, we need to understand some words that are used in the law. These words have special meanings that may be different from what we use in everyday life. Sections 41 to 45 of the Penal Code 1860 explain some of these words. Let's see what they mean. Section 41. What is a special law? A special law is a law that is made for a specific purpose or situation. It is not a general law that applies to everyone or everything. For example, there is a special law called the Narcotics Control Act 1990 that deals with drugs and drug-related crimes. This law is not part of the Penal Code 1860, but it is still a valid law that we have to follow. Sometimes, a special law may have different rules or punishments than the Penal Code 1860 for the same crime. For example, under the Penal Code 1860, stealing something worth less than 500 takas is punishable by up to 3 months in jail or a fine or both. But under the Narcotics Control Act 1990, stealing any amount of drugs is punishable by at least 2 years in jail or a fine or both. So, when we read the Penal Code 1860, we have to remember that there may be other special laws that also apply to us. We have to follow both the Penal Code 1860 and the special laws, unless they contradict each other. If they do, then we have to follow whichever law is more recent or more specific. Section 42. What is a local law? A local law is a law that is made for a particular place or area. It is not a national law that applies to the whole country. For example, there is a local law called the Dhaka Metropolitan Police Ordinance 1976 that deals with the police and public order in Dhaka city. This law is not part of the Penal Code 1860, but it is still a valid law that we have to follow if we live in or visit Dhaka city. Sometimes, a local law may have different rules or punishments than the Penal Code 1860 for the same crime. For example, under the Penal Code 1860, Making noise or causing disturbance in a public place is punishable by up to 6 months in jail or a fine or both. But under the Dhaka Metropolitan Police Ordinance 1976, making noise or causing disturbance in Dhaka city is punishable by up to 1 year in jail or a fine or both. So, when we read the Penal Code 1860, we have to remember that there may be other local laws that also apply to us depending on where we are. We have to follow both the Penal Code 1860 and the local laws, unless they contradict each other. If they do, then we have to follow whichever law is more recent or more specific. Section 43. What does illegal mean? Illegal means something that is against the law or forbidden by the law. For example, killing someone is illegal because it is against the Penal Code 1860. Driving without a license is illegal because it is forbidden by the Motor Vehicles Ordinance 1983. If we do something illegal, we can be punished by the law. The punishment depends on how serious the illegal act is and what kind of law it breaks. For example, if we kill someone, we can be punished by death or life imprisonment under the Penal Code 1860. If we drive without a license, we can be punished by up to 3 months in jail or a fine or both under the Motor Vehicles Ordinance 1983. Sometimes, something may be illegal under one law but not under another law. For example, drinking alcohol is illegal under the Prohibition Act 1991, but not under the Penal Code 1860. In that case, we have to follow the law that makes it illegal, unless there is a good reason to do otherwise. Section 44. What is an injury? An injury is any harm that is caused to a person's body, mind, reputation or property. For example, if someone hits us and breaks our arm, that is an injury to our body. If someone insults us and makes us feel bad, that is an injury to our mind. If someone spreads false rumors about us and makes others hate us, that is an injury to our reputation. If someone steals or damages our things, that is an injury to our property. Some injuries are more serious than others. For example, breaking someone's arm is more serious than scratching someone's skin. Insulting someone's religion is more serious than insulting someone's clothes. Spreading false rumors that someone is a thief is more serious than spreading false rumors that someone is lazy. Stealing or damaging someone's house is more serious than stealing or damaging someone's pen. The law tries to protect us from injuries and punish those who cause them. The punishment depends on how serious the injury is and what kind of law it breaks. For example, if someone breaks our arm, they can be punished by up to 2 years in jail or a fine or both under the Penal Code 1860. If someone insults our religion, they can be punished by up to 2 years in jail or a fine or both under the Penal Code 1860. If someone spreads false rumors that we are a thief, they can be punished by up to 2 years in jail or a fine or both under the Penal Code 1860. If someone steals or damages our house, they can be punished by up to 7 years in jail or a fine or both under the Penal Code 1860. Section 45. What is life? Life means the state of being alive or living. For example, we have life because we can breathe, eat, move, think and feel. A plant has life because it can grow, make food and reproduce. A rock does not have life because it cannot do any of these things. The law tries to protect our life and punish those who take it away or endanger it. The punishment depends on how and why they do it and what kind of law they break. For example, if someone kills us intentionally and without any good reason, they can be punished by death or life imprisonment under the Penal Code 1860. If someone kills us by accident or by mistake, they can be punished by up to 10 years in jail or a fine or both under the Penal Code 1860. If someone tries to kill us but fails, they can be punished by up to 10 years in jail or a fine or both under the Penal Code 1860. If someone does something that puts our life at risk but does not harm us, they can be punished by up to 6 months in jail or a fine or both under the Penal Code 1860. The Penal Code of 1860 is a law that tells us what kind of actions are crimes and what kind of punishments are given for those crimes. A crime is something that harms or offends other people or society. A punishment is something that makes the person who did the crime suffer or regret their action. The Penal Code has many sections that deal with different kinds of crimes. In this article, we will learn about 5 sections that are related to the meaning of some words that are used in the Penal Code. These words are man, woman, person, public, and year, and month. These words are important because they help us understand who can commit crimes and who can be harmed by crimes. Section 46 says that the word man means a male human being of any age. Section 47 says that the word woman means a female human being of any age. Section 48 says that the word person includes any company or association or body of persons, whether incorporated or not. This means that not only human beings, but also groups of people or organizations can commit crimes or be harmed by crimes. Section 49 says that the word public includes any class of the public or any community. This means that when a crime affects or offends a large number of people or a specific group of people, it is considered a crime against the public. Section 50 says that the word year means 365 days and the word month means 30 days. These words are important because they help us calculate how long a punishment can last for a crime. To understand these sections better, let us look at some examples of cases where they were used. In a case called State vs. Ram Singh, 1951, the court said that a person who was born as a male but had undergone a sex change operation to become a female was still a man under Section 46 of the Penal Code. This was because the law did not recognize such an operation as changing the sex of a person. In a case called Emperor vs. Mount Dhirajlal, 1914, the court said that a woman who was married to another man but lived with a third man as his wife was still a woman under Section 47 of the Penal Code. This was because the law did not recognize such a relationship as ending the marriage of the woman. In a case called State vs. J.C. Chatterjee, 1972, the court said that a political party that had organized a violent protest against the government was a person under Section 48 of the Penal Code. This was because the law considered such a party as an association or body of persons that could commit crimes or be harmed by crimes. In a case called Kedar Nath Singh vs. State of Bihar, 1962, the court said that making speeches that criticized or insulted the government was a crime against the public under Section 49 of the Penal Code. This was because the law considered such speeches as affecting or offending any class of the public or any community. In a case called Emperor vs. Barendra Kumar Ghosh, 1924, the court said that when calculating how long a person had to stay in jail for committing murder, 1 year meant 365 days and 1 month meant 30 days under Section 50 of the Penal Code. This was because the law used these words to measure the duration of punishments for crimes. Section 57. This section tells us how to calculate the length of imprisonment for different offenses. It says that 1 year means 365 days, 1 month means 30 days, and 1 day means 24 hours. It also says that if a person is sentenced to imprisonment for life, it means imprisonment for 30 years, unless the government decides otherwise. Section 60. This section tells us how to deal with a fine, which is a sum of money that a person has to pay as a punishment. It says that if a person is sentenced to both imprisonment and fine, and he cannot pay the fine, he has to stay in prison for some more time until he pays the fine. It also says that if a person is sentenced to only fine, and he cannot pay it, he can be sent to prison for some time instead of paying the fine. Section 63. This section tells us what is movable property, which is anything that can be taken away from one place to another. It includes things like money, clothes, books, animals, etc. It does not include things like land, buildings, trees, etc. Section 64. This section tells us what is wrongful gain and wrongful loss. It says that wrongful gain is when someone gets something that he should not get, and wrongful loss is when someone loses something that he should not lose. For example, if someone steals your money, he makes a wrongful gain and you suffer a wrongful loss.